Hello and welcome to our LinkedIn Live. Today we're excited to explore the topic of expert witness admissibility and the evolution of Daubert and Robinson challenges with a true pioneer in the field. Larry Cotten of Cotten Schmidt is a 46-year veteran trial lawyer based in Fort Worth, Texas. Larry was the first litigator to successfully challenge an expert witness under what's known in Texas as a Robinson challenge. And it's based off the landmark DuPont versus Robinson Texas Supreme Court case in 1995, which adopted the Daubert standard for admissibility of expert testimony under Texas Rule of Evidence 702. The discussion will be led by our very own Chris Dominic, a senior strategy and jury consulting advisor here at IMS. Chris and Larry will discuss the strategies attorneys should consider when challenging or defending expert witnesses, and how to position your case for success in Daubert hearings. Now, over to you, Chris.
Hey, thanks, Adam. Larry, welcome.
Thank you.
Great to have you here. Hey, could we start off by you telling us a little bit about what was at issue in the Robinson case all those years ago?
Absolutely. This was in the early 90s, and there was a series of lawsuits across the country brought against the DuPont company with claims that a DuPont product, agricultural product called benlate, which was a fungicide, was doing harm to plants. And it started off with ornamental plants. And these were commercial operations that sold the ornamental plants. And the plaintiff's bar had hired a witness out of Oklahoma State by the name of Carl Whitcomb, a PhD horticulturist. And Carl Whitcomb served as the expert witness in all of these cases that were brought in multiple states, and then eventually to Texas.
Okay, so that was 30 years ago, right? Or
Yes.
30-ish years ago?
Yes.
Okay, I looked this up. It's been cited over 1,600 times in the appeals court. Got to be more in the trial courts, right? What are some of the strategies that you now consider in a Robinson challenge? And correct me if I'm wrong, but Robinson's largely based on Daubert, right?
Exactly.
So in a lot of ways, this is going to apply to Daubert and Robinson. Okay.
It was the Daubert case that brought to my attention that when that case came out, I read it, and I immediately thought, well, let me look at the federal rule 702, and let's look at the state rule, Texas Rule 702. They weren't quite identical, but they're extremely close. Mm-hmm. So I thought it might have application to assist us in the defense of DuPont in that case. I used the Daubert case as sort of a template for how to go at Dr. Whitcomb.
I get it. Okay, so maybe let's just take this from both sides then. Let's go to your advice. If you're the proponent of the expert, what approach do you take? What's your general strategy?
Well, I think it's important that the very first thing you do when you identify your expert witness, and I understand IMS actually serves to help provide expert witnesses. You need to be sure and find someone that's in the right field. That's very, very important. And you need to not just rely upon the fact that they have that expertise and say, okay, here's my facts, go ahead and prepare a report. You need to first make sure that they know the legal side of it as well as the scientific and factual side of it. So you want to sit down with them and make sure that they're prepared to be able to address all of the aspects where they may be challenged in the future.
Mm-hmm, absolutely. Okay. So what if you flip it over? What if you're now on the other side and you've got to get an attack strategy going?
Okay. I think the very most important thing you do there is you do a lot of homework. Mm-hmm. You get as much information about that expert witness that's on the other side that you can get. You try to find out that, in fact, our rules in Texas require the other side to provide for the expert witness the last 4 years where they've given deposition testimony or trial testimony. So that can provide you with a lot of fodder to consider, ammunition, if you will, that you can use against them because of the positions they've taken in the past. Yeah. So that's very helpful. as we did in the Robinson case, you want to go through when you eventually take the deposition of the other side's expert, you want to go through all of those factors to see if they've really addressed them or not.
Yeah, that makes a lot of sense. I was just thinking about how that transitions into things that we both work on, things like preparing the witness. One of the things that's really essential in these situations is how do you make sure that the communication from this individual, if it's let's flip back to it's your person, right? It's
all right.
You're sponsoring them. You want them to be qualified. They need to come across a particular way. What are some of the things that you feel are important in that preparation session?
I think it's extremely important that you do that in person. So we rely so much on telephone conversations and communications and Zoom and things like that. It's better if you're in person. Develop a relationship with that expert. Develop, if you can, a sense of trust between the two of you. And then I think they're more receptive to, they know a whole lot more about their field than I'm going to ever know. Okay, so, and I can trust them to be able to demonstrate that. But what I want to make sure is that they're comfortable with my advice, which is to, here are some things that you need to be concerned about technically in the courtroom, or you may never get to testify in front of the jury.
Right, absolutely. And I'm curious, I mean, early in a case that has the likelihood of being Robinson challenged, this is going back a little bit. When do you do the expert search? Like, let's talk about the litigation life cycle. What's your timing around that?
Well, if you're on the plaintiff's side of a case, that's going to be one of the very earliest things that you do, maybe even prior to your filing your lawsuit. In fact, I suspect most of the time it's well prior to filing the lawsuit. Almost every case today, there are exceptions to this, but almost every case is going to have some expert testimony in it. Sometimes the law requires it. You just have to have it. And sometimes you want it because the expert can be very persuasive. And so I think you can't start early enough to identify who it is that you need on your side to help advocate for your case.
Okay. I'm curious about judges. Tell me a little bit about your approach. Do you find that judges it's so important that you get to know who they are so that you know how to approach them? Or do you find that if you do certain kinds of preparation techniques with the experts, the judges tend to respond pretty similarly? Like, where do you stand on all that?
That's a really, really good question. Just like the research you can do about your own expert or the expert on the other side, a lot of research is available to you today regarding your judges. You can make some determination as to whether or not they're inclined to grant these type motions. There are some judges that I've been before who will not grant a Robinson challenge. They just won't. They want the case, everything to go before the jury. And then there are others who realize if this witness is not going to pass muster, if there's an appeal in this case, why go through it all, go to all that trouble and expense, when on the other side, if an appeal is made and a challenge is made to whether or not that expert should have testified, the appellate court says no, and they reverse and render the case. So you want to avoid that if you can. So this is sort of a tell. I've never gone into a courtroom where I've got a Robinson challenge and told the judge that was my case.
Interesting.
And one of the reasons for that is the judges became gatekeepers. They didn't have that role until the Supreme Court adopted Robinson and adopted the Daubert, basically the Daubert template. And so it put the judges to a whole lot more work. So I didn't want to tell them I'm responsible for putting you to a whole lot more work.
That makes a lot of sense. Okay, since we're on this topic of judges, I'd like to talk about something that comes up in my world, and I want your thoughts on it. Sometimes I'll be working with an attorney or someone from the jury consulting team will be working with an attorney, we'll be preparing a witness, and we'll get the expert demonstratives. And sometimes they're impenetrable. They're just, the only person who's going to understand them is somebody in the academic department of that expert, right? And sometimes what they'll say is, well, I think they're fine because it's just for the judge. And I'll have to be the one sometimes, or one of the other jury consultants will have to say, you know, maybe we need to do a little work on these. Have you found that to be true as well? Have you had that experience?
Somewhat. You know, when you have a Robinson hearing, it's very, very important that whether, if you're the proponent, that you bring your witness to that hearing and put on the testimony for the judge and be there available not only to answer the question that the lawyers might have for him, but also so the judge could ask questions as well and satisfy that judge that they do meet all of the criteria to allow them to testify. So as much as sometimes we're talking about hyper-technical issues with regard to science or engineering or whatever the topic may be that the expert is addressing. And if you've got demonstratives that helps to translate what might be otherwise over someone's head in a way that you can see it, I think that's very helpful.
Yeah.
It's very important. And you're right, you don't necessarily want, the expert himself may not be the best communicator of that concept. It's better to have someone that knows how to get that message across.
Yeah. Larry, thanks so much for joining us today. This has been great. We really appreciate it. And thanks to everybody else who tuned in today. It's all yours, Adam.
IMS has served trusted law firms and corporations worldwide for more than 30 years and over 65,000 cases. As a strategic partner for the full case lifecycle, our integrated teams provide specialized advisory support, expert witness services, litigation consulting, visual advocacy, and presentation technology to elevate strategies and protect hard-earned reputations. Learn more at imslegal.com.